No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics that don't quite fit into all those other questions that we ask here on the Law Report. So once again, I'm joined in studio by attorney Nicoline Skuman-Lowe. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, and their practice here in Cape Town. Nicoline, good evening. Welcome to the show. It's the first time for you and I this year.
Thank you for having me, and it's a pleasure to be back in the good old 2017, which is a little older by now.
Yeah, I can't even wish you happy whatever it is, because it's like a little late now for all of that stuff, so we won't go there. We've got a few emails to get through first, but if you'd like to call in, you can call in and leave your name and number with my producer, and we'll call you back as soon as we're done with the emails. And the number is 0892 10 2010, 0892 10 2010. And always remember, when we do the law clinic, we don't include topics on property and labour because they have their own shows. So no property law questions and no labour law questions. Labour law, we're actually putting an extra program in, so we'll be having another labour law show next week. So if you have a labour question, you can phone in then. Right, Nicoline, let's get down to some of these emails. The first one says, from Musa, says, my mother died in 2006 without leaving a will, and my father was appointed the executor of the estate by the Master of the High Court in Johannesburg. It has come to our attention that my father opened a late estate bank account and monies were deposited into the account, but the Master was not informed about this account. We managed to get a cover page of the late estate bank account statement, and it has the account number. We went to the Master's office to request intervention, but we did not get help. The Master's assistants dismissed us by telling us that we need better evidence. We went to the bank to query the matter, but the bank couldn't assist us since we are not the executor of my mother's estate. It appears that the bank closed the account in 2011. My siblings and I are currently raising money so that we can afford the services of a legal practitioner. This bank account is a vital piece of evidence to prove our case, but in the meantime, may you kindly please advise me whether the account that was closed in 2011, is it possible for us to retrieve archived bank statements of this account? I was told that companies keep records for only 5 years.
Well, firstly, this is obviously a very unfortunate situation that the heirs or the survivors of the deceased find themselves in. And the banks do not only keep bank statements for 5 years. In fact, I can say this definitively because we are currently dealing with an estate late where we retrieved archive statements up to 15 years back. So it shouldn't be a problem to retrieve the bank statements. But of course, we always say don't wait for too long. Obviously, if you're not the executor of the deceased estate, there are privacy considerations, which is why the bank wouldn't want to share the statements. So a way in which you could force the bank to share the statements would obviously be to approach court, and a court order could compel them to give you insight into these bank statements. So that is one of the ways. Obviously, of course, one could also approach the Master's office, but it's clear from the evidence here, or rather the email content, that this was not disclosed to the Master of the High Court, which I must say I do find somewhat irregular, because as part of the administration of the deceased estate process as laid down by the law, the Administration of Deceased Estates Act, it's actually quite clear that you need to open an estate banking account, and you need to submit copies of the bank statements to the Master. And it's part of the process, and you won't be released as executor once everything's been concluded if you haven't done this. So the only way, so to speak, around that provision is if it's a small estate. And a small estate is an estate under 125,000 Rand in value, which is formally known as a Section 18 subsection 3 estate. So in that case, it could very well happen that statements were opening a bank account was not necessary because it was a Section 18 subsection 3 account, or estate rather, and for that reason it wasn't a prerequisite. So it could have slipped through the cracks, if I can put it that way. It's not a prerequisite, so the Master is not going to demand those records. So if an estate banking account was in fact opened, the Master wouldn't have requested copies because of the process, and therefore it could have happened. So I would just to satisfy myself that it is in fact a state of affairs, I would still obtain a copy of the master's file, a full copy.
And they don't need they don't need to be executors or anything to
No,
get
not
that.
at all. That is public document. So I would say step one, I know they are of the opinion that it hasn't been filed, but maybe it has been filed and the wrong person gave them this advice at the master's office, or someone or there was a misunderstanding of sorts. So I think first step, get a full copy of the file at the master's office.
What would that cost them? Nothing. Or would
A couple of rands per page. If memory serves me correctly, it's about R4.50 a page. So, or per record. So it could be a couple of 100, 200 rand if we're talking about an extensive file, or at least have them retrieve the file from archive at the master's office and page through it and say, okay, I would like this copy and I would like that copy once you've actually inspected the file. So I would say that is step number one, to physically go and see the file with your own eyes, satisfy yourself that these records are not in there before you end up making an application to court, and then halfway through the process it turns out that the records are indeed with the master.
And what would they need to take with them to get this record from the master's office? An ID number of the late mother?
Yes, date of death, that would be very helpful. And if they have the estate number, that would be very helpful. So those three, but with any the ID number and the date of death, or just the ID number, or just the full names and date of death, all of those those criteria would lead to the estate number, which is then the file number, and could then...
So that's where their first start.
Yes.
Okay, so give that a go and let us know how you go, because there are possibly some ways that you can do this without having to spend too much money. So have a go and let us know how it goes. Right, the next email is from Michael. He says, I had a summons submitted to my HR department whereby they received and signed it on my behalf without me knowing about it. And then he sent a lot of attachments, and says here, as you can see on the attachments, the initial amount that was owed to the doctor was 320 Rand, and now the attorneys are informing me that I have to pay the total of 960 Rand and some change. The attorneys never called me at all, but just pitched at work to submit these papers they call summons. Please let me know if this is right.
Unfortunately, I hate to be the bearer of bad news, but this is something that we see happening regularly, where bad debt is handed over to debt collectors or attorneys, and a fairly small amount then escalates to a fairly large amount. Now, of course, one of the aspects that one can look at from a legal perspective is whether or not the account is subject, or the provider, the doctor in this case, if their accounting system should be subjected to the National Credit Act. And if that is the case, then there's a rule that says once the debt has accrued interest or charges to the amount of the debt, it stops running. Formerly known as the induplum rule. So there could be a reduction in the cost, but unfortunately at that stage, if an arrear account has been handed over, there's always interest charges, and there will always be legal charges. It's just a question of how much. So best case scenario, you could look at it reaching the 320 times 2 mark, which is 640 as opposed to 960. But before all of this, given that it's a fairly small amount, if I was the listener, purely from a cost perspective, I could imagine if there was some error and he doesn't owe the money, it could be a matter of principle, but I would actually simply make an arrangement of sorts, possibly with the doctor directly, if they're willing to speak to you, in full and final settlement, and that way maybe negotiate a bit of a discount.
But I think what he's also on about is the fact that they arrived at his work. He didn't even know about this thing, and the HR department just signed it on his behalf. That's what he's asking. Can they do that?
Unfortunately, the HR department is anyone over the age of 14 and of sound mind, which means it's a person on whom service of legal documents could legitimately take place. Similarly, if your mother or sister or domestic worker, for example, opens the door, or a brother or some family member, and you're not at home, and they sign for something and they forget to tell you, it could have the same result, which we often also see in practice. So, yes, service of documents can definitely happen, but I would say try and negotiate with the doctor directly or with the attorneys. Make them an offer. As I say, possibly quote the National Credit Act and say, the unduplum rule provides for the judgment debt, or rather the debt, to only accrue interest and charges up to its value, so 640 Rand on that basis. And hopefully that resolves the issue. But defending it in court and getting yourself an attorney, in my view, wouldn't justify the cost in terms of the amount outstanding. You'll end up spending more money.
Yeah. Right, okay, the next email is quite a long one from Mbukhle. Mbukhle actually got an LLB degree and passed all the board exams, further completed part-time professional legal training courses as required. The problem is that the PLT certificate has not been given. And now there's a problem with this, and there's apparently some assessments that had to be completed, and it just sounds like an absolute nightmare. I mean, this happened a while ago, and it's like, and the booklet can't practice now.
Yeah, it's quite shocking actually, and it is quite a long email, and really I can just see the frustration and the disappointment in it. So, in a nutshell, where you as a upcoming legal practitioner would complete your articles, you would your principal, as part of your articles that you'll serve, usually to some degree assists you with the admissions process as an attorney. So my first piece of advice, and possibly a more practical piece of advice than anything else, is for her to actually approach her principal, the person who she did her articles with, for listeners who are not aware of all the jargon that we are using.
There's also this whole story about these assessments that had to be done, but they weren't told where to go and what they were supposed to do. And eventually Mbukhle actually contacted the Attorneys Fidelity Fund in November. Now, this all happened in June of 2015. When it started. In November of last year, so that's more than a year later, contacted the Attorneys Fidelity Fund, and then they got back to Mbukhle and said, oh, well, they then told her where these assessments were to be completed. But they said that they could now complete the assessment, but they didn't give them any information about where to go and do this. I mean, this whole thing just sounds... It says here, as it is, still today, I do not know what to do, where to go to get help. I'm sitting with a qualification that at the moment has no value to me without my admission. I'm unemployed, unable to apply for anywhere. Without my admission, I'm basically untouchable. I have no source of income, and my family is suffering as I was the sole breadwinner. I mean...
Yeah. Now, as I was saying, your first point of call is to approach your principal.
Would they be able to sort out this whole assessment story? Do you know what is this assessment story, first of all?
Well, no, I'm not part of the governing body of the Law Society. And unfortunately, it's a different law society to the one we belong to. Okay. So every law society there are national rules, so they are broadly speaking the same, but every law society has a different structure and different administrative processes. So the first point that I'm trying to make is that your principal through which you've done your articles is someone who not only teaches you the practical side of legal practice, but also assists you in the admissions process. So that person has to sign certain paperwork, including affidavits, which helps you in your admissions at the end of the day. So my first point of reference and advice to her is approach your principal and ask them to intervene for you, to phone someone at the Law Society to get some clarity and to resolve the issue. That's the first point. If that person is unwilling or unable to assist, the next point is, of course, to attend the Law Society. In other words, go there and sit there until someone, preferably the head of the Professional Affairs Department or the Admissions Department, speaks to you and get the full details of what happened, why am I in this position, and what do I do from here, and what type of assistance are they willing to give?
Now, she says here that part of it, she actually sent a complaint to the Attorney's Fidelity Fund. Maybe she should not try the Law Society, not the Fidelity Fund.
I wanted to make that point in closing, that the Attorney's Fidelity Fund is in essence an insurance provider. They issue our Fidelity Fund certificates, which allows us to practice law. And if there is any question of unprofessional conduct or theft or something along those lines, then of course an aggrieved party can claim against the attorney, and the Fidelity Fund settles such a claim on the attorney's behalf. So in a nutshell, the Fidelity Fund is like an insurance body, a professional insurance body for attorneys. Of course, you are free to obtain additional insurance, but that's the most basic assurance that the public is given from a professional services and standard perspective. So they do deal with us as attorneys on a certain level when we are getting our financial or our admissions in order, but they are not our direct contact. That is for the Law Society. The Law Society also presents the practical legal training courses. They deal with the admissions exams, and so on.
So maybe all of this could be sorted out if she contacts the Law Society.
She needs to contact her local Law Society,
Where
in my
is she?
view.
Yeah,
and she needs to see someone in the Professional Affairs Department or someone in the Admissions Department.
Durban. Okay.
Preferably the head of either of those departments. Those are the guys who know how the process works for admissions, and they will draw your file as a candidate attorney. They'll be able to see which of your requirements are not fulfilled and what to do about it.
So the Law Society pays it in,
yes.
basically, and then she should have at least some help from them.
Yes, the Fidelity Fund, in my view, won't be very helpful at this point. But I do suggest also that she still tries and gets the assistance of her principal. That's part of your legal duties towards your candidate attorney, is to guide them and help them through the admissions process.
Right, okay, Mbuhle, please let us know how it goes, because it sounds like you've been on quite a mission for almost 2 years now, which is quite ridiculous. Right, okay, the next email is from Jill. It talks about, basically she's from an NGO, and they've got a client who has little in the way of resources, and given this limited amount of evidence, she wants to know whether their client has a reason to pursue her claim. And the claim is, according to the deceased's written wishes, which I think is the sister of the client, 10% of her estate was to go to her sister. However, the trustees, after doing an investigation, said that that person was not financially or factually dependent on the deceased. Should that even be a consideration if it was the deceased's written wish? Apparently, the deceased used to pay for her sister's groceries and gave her money to pay her society's fees, but it was always as cash, and so there was no paper trail. Now, we do actually have Jill sent through late this evening a copy of the actual life insurance policy, I think. What is it?
No, it's actually a retirement fund. It's a retirement fund, and so in essence, it's an insurance policy, and we are talking particularly about the nomination of beneficiaries for the death benefits portion.
And it actually states their client's name on there and the 10%.
Yes, and that person's date of birth. So the person is properly identified. The percentage that she should be getting is properly identified. I don't see why the insurer has rejected this.
So I just want to ask you, just say, for example, God forbid something happened to me, and I had nominated my husband to inherit from me. Now, he isn't dependent on me. I'm more dependent on him than anything else. Would he then, the way this is going, would they then say, no, sorry, you can't have any of the money? No, because that's what they're pretty much saying now.
Yes.
I mean, which is just doesn't make any sense.
It is quite irregular in my opinion. We've also got a letter, presumably for the reasons for their finding, and it basically says that a consultation was had where all the other beneficiaries, obviously we're not going to name any names here, were interviewed, and then that it was confirmed that there are no minor children or other dependents that were dependent on the deceased. and that there's only one child and a grandchild and so forth. But what concerns me really is that they say that the findings that this person was dependent and this is this person's affiliation to the deceased were all done in consultation, which doesn't convince me that a proper investigation was held in terms of authenticity of who are the remaining beneficiaries, who they say they are. It merely says the above were all discovered through consultation.
Well, I could have pitched up and said,
irregular.
I'm a beneficiary and I also want 10%.
No, sure. So what is useful though, so besides the fact that this is constructed, in my view as an attorney, as somewhat irregularly, it does count in her favor, because it says recommendation that it's recommended that the benefits be distributed as per the expression of wish form. And this is the expression of wish form, which clearly states that the sister needs to get the 10% along with the 3 other beneficiaries in their proportions as nominated. So even though this is a fairly strange document, it is in her favor.
The last sentence is the most important.
The last sentence is the most important. Why they haven't followed this is absolutely shocking.
If they don't pay it out, even after they've said that, what do? Go to the Ombud for what? Short-term insurance? Long-term insurance.
Long-term insurance.
Okay.
And obviously, if this has been, I see this has been going on for quite some time. So they'll have to explain why it's taken so long, and of course there are financial reasons. So they'll just have to set that out in a condemnation, in a condemnation portion of the referral to the ombudsman. So that won't cost any money. They can contact the ombudsman directly and fill in the forms. They are very, very helpful at the ombudsman's office, and they can make further investigations and at least shed some light on how these processes have been applied. But if
I was Jill, I would actually take a highlighter and highlight that last sentence, because that last sentence actually is them saying we have to do what it says on the wishes form, which is what the sister's supposed to get, the 10%. So highlight that last bit and then take it to them and say, right, well, here I am. You wrote that. Can I please have my client's money now? You know, I mean, they said it.
I mean, no one is obviously challenging the authenticity of this this nomination form, as we usually call it, and it's very much standard practice for you to approach an insurer and to, on their beneficiary nomination form, to nominate who you want to benefit, the policy
anybody
to benefit from. So it's definitely not an irregular process to follow, and you don't have to mention it in a will. So the will is quite irrelevant in this circumstance. They have to follow it unless there's some strange provision in their policy regulations or the fund's rules, in other words. But I would be very surprised. So refer this to the ombudsman as a matter of urgency.
If they don't take your highlighted portion and do something. Right. You tune to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is attorney Nicoline Skuman-Low. She's the director of Skuman Law Inc., attorneys, conveyancers and notaries, public practicing here in Cape Town. If you have any questions, you can call us on 0892 10 2010.
Come Dine With Me SA. The show that took South Africa by storm is coming to SABC3. In each episode, 4 complete strangers visit each other's homes, sample their cooking, and pass judgment on their entertaining skills, all with the hope of winning 10,000 Rand. So if you want to be part of Come Dine With Me SA and live in Gauteng, have loads of personality, love entertaining and can stand the heat in the kitchen, then go to sabc3.co.za to enter. Entries close on Sunday, 26 February. Come Dine With Me SA on 3.
Onside, a shot in! Oh, what a beautiful goal! The waiting is finally over. Calling all fans and lovers of the beautiful game. The Premier Soccer League is back with Show Me Your Number. Great saves, chibobos, and fantastic goals. SABC Sport brings you the PSL action midweek and weekend. For the love of the game, be part of the action by tuning to SABC One and your favorite SABC radio station. Proudly brought to you by SABC Sport.
No one lays down the law like Karen Key. This is the Law Report on SAFM.
Right, back to some of the emails. We just have 2 more emails left. The first one was actually something I think that came up on Facebook, and it said, what is the law regarding the smoking of cigarettes in the office in the presence of non-smokers? What is the solution? Now, I did reply to the listener and said, as far as I was concerned, that it was illegal to smoke indoors in an office, in a public place. But I would ask you, maybe I got the wrong end of the stick, but I was almost sure that it was completely illegal. So it's not even in the case of non-smoke, in the presence of non-smokers, you can't do it.
Yeah, you can't do it. It's a common principle, and in most office buildings these days are in fact smoke-free zones, and that would include common areas and the parking garages. So it often extends to outside of the building as well.
There was like a distance or something from the entrance or whatever it was.
Yes,
I remember a couple of years
ago. It's quite
ago.
highly regulated now, so most definitely not allowed in the office setup itself, regardless of you're a smoker or non-smoker. So I
was right. Oh,
yes,
good.
you were
I
right.
get things right occasionally. Right. Okay. Our last one is from Chris. Says, can an attorney who helped my deceased aunt to draw her will claim for money, 35,000 rand, from my aunt's daughter after my aunt has been buried, saying that my aunt owed him for drawing up the will? The attorney wants the daughter to sell one of the cars so he can be paid. The same attorney says he is entitled to a percentage of the total amount of my aunt's estate. He says that is the way it's done, saying the family of the deceased must write down all the assets my aunt left behind so that he can bring a person who will evaluate the cost of these assets. Then about 3 or 4% of the total cost must go to him for reporting the death of my aunt to the magistrate of the High Court and for being chosen to administer the estate. Is that the norm? Who chose him? Does he have to produce a proof to us that he has been chosen by the Master of the High Court? He also claims to be one of the 2 people who are trustees to my aunt's trust. How can we challenge him to prove to us that he was chosen by my aunt while she was still alive to be one of the trustees? My aunt was running 2 big, well-established places which accommodate orphans, neglected children, unwanted and homeless children for years. She raised up a lot of children and was still busy with that when she passed away. She had lots of donors and 3 vehicles, including a bakkie, and her properties are huge. Please help urgently, as that attorney is harassing my aunt's daughter. Right, okay.
Okay, I think let's quickly take a step back. First things first. Obviously, if the attorney has been appointed as the executor of the estate, then and a trustee, so 2 different offices, but we don't have time to really dig into it. So if the attorney has been appointed as both the executor and the trustee, yes, he is entitled to a fee. That's the first general answer, yes. So secondly, they need to ensure that they see a copy of the will, and if they have any concerns regarding its authenticity, in other words, that it was his aunt's signature on that will, they need to get an attorney of their own and challenge the authenticity of that will. Then, obviously, in the will as well, they would set up a trust, a testamentary trust usually, and that's where the trustees would be appointed. Or if there's a different type of trust, in other words, an inter vivos trust, or that already existed while she was still alive, they'll have to approach the master's office, get a copy of the trust deed as well as the master certificate to see if this attorney is a trustee there, if he's not nominated as a trustee and executor in the will. So first point is to get a copy of the will to see if this person has been nominated as both those that he claims to be. That's how they can convince themselves. If they have any doubts regarding the authenticity of that document, get an attorney and challenge it. If he isn't appointed as a trustee in there, then obviously it can only be that there is another trust that exists and existed during her lifetime. And then the step there would be to obtain a copy of the trust deed and master certificate to see if he has been appointed lawfully as a trustee of that inter vivos trust. So those are the first investigative points, call it that. Then if we've convinced yourself there's no fraud on the documents and this person has been appointed, then yes, they are entitled to charge 3.5% plus VAT on the total asset value of the estate. That is a statutory regulation. Of course, unless you can prove cause why it should be reduced. So once this person has been appointed as executor, then of course they'll start collecting information about assets, which will include approaching some of the heirs and saying, please make a list of everything in the house and so on. So that's quite usual to ask for that. And it's quite usual also to have a valuer look at all the assets and to value them and see if it's reasonably valued so that you can get to an amount or a value of the total estate. That's also quite usual. Nothing to be too concerned about. But the executive fee is negotiable, unless, of course, the will has stipulated that it will happen at the statutory tariff, which is 3.5% plus VAT.
Now, what about trying to get them to sell one of the cars? Can they do that?
Unfortunately, if there is a will that appoints the executor that prescribes the fee, and usually there's a standard clause that says something along the lines of, my executor shall in his or her sole discretion be able to sell any of my assets, paraphrasing of course, then it's completely lawful and it can happen. And sometimes those clauses go even further and say without the interference of any of my beneficiaries or heirs. So it all rests on the will. You need to get a copy of that document, and if you have any concerns regarding authenticity or if there are any uncertainties regarding the interpretation, you need to approach an attorney and get some advice. Sooner rather than later.
Yes, I know you just say it's urgent, so let's hopefully that's what you said, told him now will help. Right, let's get on to some calls now. We're going to go off to PE. Ralph, good evening.
Hello, Corin.
Hi, Ralph. How can we help you?
Corin, thanks. My question is for Nicolene. My mother was deceased in April of 2016. I didn't know the procedure. The Department of Justice pointed me in the direction of a firm of trustees who I basically hired because I didn't know what to do. So I've been dealing with them since August of last year. Now, the contact between then and now has been intermittent at best. I've constantly I've asked them for an interim statement, for example, because I said in the beginning, what is this going to cost me? I'm still waiting for that. The money that has been left to the family is tied up, and a class action was brought against where the money is. I won't have to mention who they are. The High Court has granted a judgment. I've now received a document from the class action attorneys that I have to sign by it has to be submitted on their desk by Monday of next week. I emailed the trustee last Thursday morning requesting him to contact me urgently because I need to know what I'm signing. I heard nothing from him Thursday. I heard nothing from him on Friday. This morning I emailed him again because time is running out. I got a very almost offensive reply as if to say he knows what he's doing. And there was no apology forthcoming for his tardiness. My question is essentially, I'm at the end of my tether in terms of their general apathy, and there's, it's a reasonable amount of money involved, and I don't know who to turn to. I mean, well, that's my question. Do I sort of, am I in a position to say, well, because I had a very much shooting from the hip meeting with the trustee about 3 weeks ago. We assured me that everything, that I said was accepted and that they would in future do their best. Well, they haven't. And it's almost given me sleepless nights because I don't know where to go from here because I'm now absolutely in his hands. So that's just my question. What do I do?
Okay. Well, firstly, I'm really sorry to hear that you're going through this. It's traumatic enough to have to deal with the loss of a loved one. So, firstly, I would suggest that you obviously, well, I know this may sound harsh, but you need to put the trustee to terms to say, I want a response clearly in no uncertain terms on these questions, and I need to understand what I need to do about this by X date. And if that doesn't happen, I would actually suggest that you terminate their services. You can do that even once they are appointed as an executor of the estate. So if that's even how they've been appointed. In most instances, if you were appointed as executor, for example, then you can approach a firm of attorneys or trustees or however they conduct these services, and then they usually act on your behalf as executor. They don't actually go through the appointment as such. So it depends how you've appointed them and how easy or how difficult it would be to terminate the services. But if you're not getting any certainty, as opposed to it dragging on for another 2-3 years, I would recommend that you strongly consider terminating the services, and rather, if they are appointed as the executor, have them removed.
He says he's the executor of the estate.
Well, that makes it much easier. So if they're only your agent,
I'm the sole executor.
if then they're only acting as your agent, and then you can terminate their mandate at any point.
Because I think you've given me what I need to go on with. My point is that this is not critical because the document has to be lodged, signed by myself by next Monday. And my question to him per email of last week was, I need to know that what I'm signing, but I can interpret most of it, but there's certain questions that I had pertaining to the document, i.e., just the how the money is going to be repaid, etc. And I felt that I was simply fobbed off today, and he said, well, leave it to me. But I don't want to leave it to him for the simple reason that I need him to find out for me. I can train the attorneys myself, I guess. But, the word trustee to me implies the word trust.
Yeah.
I know that's not the official definition, but
No, sure.
I trust him. And my trust has been completely broken.
No, I completely understand that. So I would recommend, you are the executor of the estate, and at the end of the day, you are the responsible person in order to deal with this as best you can. So if you feel that the trustee is not assisting you in this process to the degree that they should, I would recommend that you terminate their mandate and don't pay them for their services.
Okay, well, this has been very valuable, and I appreciate it. And I'm just going to ask you, and this is absolutely the end of my saga, and I appreciate your and Corin's assistance, because time is of the essence now. By Monday, as I'm said before, these documents have to be with the attorneys that instituted the class action. And his arbitrary reply to me today was, I'll attend to it during the course of the week. That gives me absolutely no confidence whatsoever.
No, I would be on tranquilizers at this point, Rolf.
Well, I'm nearly there. I'm chain smoking.
Okay, well, that's not good either. But yeah, no, you can't take a chance. What if he doesn't do it by Friday and this thing's going to be on Monday? No, that's just. Can he actually tomorrow morning say, look, I'm really sorry, but I no longer require your services? And he could appoint another, maybe attorneys tomorrow who would look at the thing tomorrow.
Yes.
And he would know by tomorrow.
Yes.
Rolf, you can do it all tomorrow, basically.
Well, that's how I live my life. It must happen immediately.
You sound like me.
No,
Okay.
I would recommend that you do that and find, just make sure that it's an attorney that understands deceased estates and that does understand class action. So you need to look for a firm that does both deceased estates and litigation. You can't just look for a firm that only does one.
Yeah, I think I know who to go to in that respect. So if I can just clarify, I mustn't approach another. These people call themselves a trust. Oh, I nearly said the name. Somebody trust.
Yes.
No.
They
So
are
I don't
probably
go to
also
another
not
trust.
attorneys.
You
I
need
go
attorneys.
to attorneys.
You
But
need
if you're
attorneys.
looking for specific attorneys, possibly because PE would fall under the Cape.
Yes.
Maybe if you phone, it's the Cape Law Society because
Yes.
PE is in the
Okay.
Eastern Cape.
Excellent.
They would be able to
Okay,
direct
great.
you to attorneys who specify in particular types of law. So
Okay,
if you're
perfect.
stuck with anything or not being able to find the correct one, just get hold of the Cape Law Society
But terminate the mandate.
tomorrow morning.
Nicolene and Corin, thanks a lot.
Hang on, Ralph, before you go, just one thing
Yes.
Nicolene said. You said don't pay the account. He's going to be back on the phone telling us he's being sued by them. What, you told him not to pay their account.
No, don't pay
No,
their
I'll-
account.
I'll just-
if they feel they want to.
But they haven't even given
claim-
him a statement. He asked them for that, and they've given him nothing.
Unfortunately, from my experience, that's what these guys do. If you terminate the mandate, then they say, "Oh, okay, I have to compute my account,
But they've
and
been
then
asking.
I'll hand over the documents and whatnot." So
Okay,
I wouldn't
yeah,
pay them if I was you, and if they kick up a stink, so to speak, about the payment, then there are channels that you can use to address that, and I would do so through an attorney. They'll essentially have to prove that they've acted accordingly and that they
haven't done.
Yes.
Yeah, just for possibly for the other listeners, I've learned through the School of Hard Knocks to keep paper trails. So, for example, I requested an interim statement from them per email. I've got the whole paper trail of their not responding to emails of mine. So I think, very confident that they will be found culpable in terms of non-performance.
Oh, definitely. So the masters in any event, there's good precedent that in your favor, where the masters actually denied the claim for executive fees in situations like this. So
Okay. Okay.
But if it escalates, just to have your new attorney deal with it, and it's always better to rather approach attorneys in these instances because we are part of a professional body, and if something goes wrong, there's someone you can complain to. These guys that practice under trust structures and different ways that are not attorneys are often, if something goes wrong, you can't really
no fidelity
pursue
fund,
them.
basically.
There's no fidelity fund, so if they really cause a massive damage, then you're stuck.
I'll sleep well tonight.
Good luck,
Thanks
Ralph.
very much.
Okay.
Good luck.
Good night.
Okay,
night.
bye-bye.
Bye-bye.
Well, we'll be back shortly. We're just going to take a short break, and we've got some more calls on the line.
Wanting to do business in the African energy sector and looking for energy-efficient technologies for business and home? Register now to attend the Africa Energy Indaba Conference and Exhibition. With top energy experts, energy companies exhibiting, and energy project deals presented, you can't afford to miss out. From 21 to 22 February at the Sandton Convention Center. Register now at africaenergyindaba.com.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, taking more calls after Yeovil. Ben, good evening. Hello, Ben. Oh, we seem to have lost Ben. Ben was there. We'll get back to Ben shortly. If you could just take this call off the line, that'll be great. Thank you. We'll get on to some more. While we're waiting to get Ben back on, Rashad called in. By the way, if you'd have any questions, we've got about 10 minutes left. We can squeeze one or two more in. 0892 10 20 10. But in the meantime, Rashad called in. He was medically boarded 15 years ago. He apparently owes 20,000 Rand, but he doesn't own anything. He's got no income, and he stays with his son, and he wants to know what can they do to him. Now, it doesn't say here what the 20,000 was from or how long it's been owing, but yes, he was boarded 15 years ago, and I'm assuming this is an old debt.
Yeah, sure.
It could have prescribed by now.
It could very well have been. So I would say, firstly, see when the debt occurred and when the summons was issued. And if there's more than 3 years between those dates, then address it by pleading prescription. And then it should address the issue completely and extinguish the claim. If that isn't the case, because there's no source of income, you can't do what we call a Section 65, in other words, where you garnish a salary and the employer pays a monthly amount. Obviously, if he stays with his son, he's obviously presumably doesn't own the property. So again, there's no fixed asset. So then they'll probably, if they get a judgment for the 20,000, they can't attach a salary and they can't attach a fixed property, then you're only left with one, and that is movable assets. But again, if the sheriff shows up and you can prove that you don't own any of the movable assets that he or she wants to attach, like the car or the maybe the electronics or something of substantial value, then of course the sheriff will indicate it as such, and then the creditor in those terms they're pretty much stuck between a rock and a hard place.
Okay, well, let's just talk about the prescription thing now. It's got to have been more than 3 years.
3 years or more.
from when that account, essentially
When
had
the account was
anything to
rendered.
do with it, basically. Because if that account is sort of, say, 6 years old, but last month you suddenly decided to pay 100 Rand off the 20,000 Rand,
opened
then
it
you've
up.
reopened the thing again, which means that it's now current, and now you cannot claim prescription, even though the account is very old. So if
Yeah.
that account is more than 3 years old and you've made no payments, you've made no claims on that thing, you haven't admitted anything in writing or verbally on the phone to anybody that you owe the money and yes, you will pay it, you can claim prescription. But this
Yes.
is not encouraging people to let your debts lie there.
No, definitely
No.
not. But still, you'll have to go to court, and you'll have to plead prescription. In other words, you have to prove that. So it's not just a case of, oh, okay, this is older than 3 years, let me ignore it. You have to actually do something about it and go to court. The other side of the coin is we're also not encouraging people to ensure that they don't own any assets so that you can't execute judgments. So if something is owing, go and make an arrangement with the person that you owe. The fact is you entered into a contract or a verbal agreement to lend in advance some money. You've had the benefit of the money, and let's act fairly towards everyone concerned. But if you have nothing and you find yourself in this predicament, I would still suggest, even though from a practical perspective, the sheriff may not find anything that they can take, rather do the honourable thing, for lack of a better phrase, and make an arrangement with the person. You've had the benefit of enjoying this money in some way or form.
Can I just, if you have something that has prescribed and you then don't have to pay it back, or there's you go to court and they find that you actually are not in any position to pay it back at this stage, can they blacklist you?
No.
Can't. Okay.
Obviously, if they get a judgment, they can blacklist you. So that's what I'm saying. Sometimes it slips through the cracks. Usually, if you apply for a judgment at court in an instance where you serve on the person who owes the money, they don't do anything, and then you apply for a judgment against them or a default judgment, then usually it gets checked by a magistrate. And if they check these little details, like if there was compliance with all sorts of applicable legislation and how old the debt is. And if it is an old debt and it lands in front of a magistrate, they usually won't grant the judgment. But if in the odd occasion it happens, errors happen, we're all human, then you may still find that you get blacklisted for a really old debt because you didn't show up at court. So moral of the story is, if there's a summons, don't ignore it. If there's a letter of demand, don't ignore it. Get some advice if you're not sure how to handle it. And if you're really struggling, rather go and make a payment arrangement with the creditor and stick to it. Do the honourable thing if you've had the benefit of whatever money or agreement affected. If you've had the benefit of it, do the honourable thing and make the arrangement to pay it back on mutually agreeable terms.
Right, and just sort of stay on the right side of the law.
Sure.
I think we've got Ben back on the line. Ben in Yeovil, are you with us now?
Yes,
Hello,
ma'am, I
Ben.
am.
Hi, Ben.
Thanks for taking my call.
Pleasure. How can we help you, Ben?
Yes, I've had two harrowing experiences with supervisors mainly. The one is a lady, the other one is it's a man. It's an attorney, I think, at the DPP, that's Department of Public Prosecution. Mm-hmm. So now this person is a disabled, but he's the boss of all the lawyers that work with the documents. So every time they've made a decision, they take it to him to say he should sign it. But now what I've experienced with him is that he does not read what he's told to sign. He just signs. And if I went to him to ask what happened here, he said, no, I did not read, I only signed. So now I feel like these juniors are undermining him. Now I'd like to know how much protection does this person get from the law since he is disabled? That's the one question. Mm-hmm. So the second one, it's at the housing tribunal. I've been running there up and down for about 2.5 years now. So the lady is a director there. Now the subordinate who's handling my case is a male. So every time when he goes for lunch, he goes for, instead of 1 hour lunch, he goes 2-3 hours. When he goes on leave, instead of 1 month leave, he goes for 2-3 months. You see, now the lady there is scared to tell him that he shouldn't do wrong things, because I went to the lady to complain about this man. So all I'd like to understand is similar to the first one. What kind of protection these people have, since women say we want to be, to have our place in this country, we want to be in positions of leadership, but they are not listened to.
Okay, we haven't got too long. We're going to be very brief with that, Nicolene. First of all, I think the first one with the disabled person, I don't think the disability should come into it all. If he's not reading the documents, it doesn't matter whether he's disabled or not disabled. He should be reading the documents.
No, particularly as a professional, as an attorney who's a supervisor or manager within the organization, a person of authority, in addition to having a profession or subscribing to a professional office, it's definitely unacceptable. Regardless of your personal circumstances, you can't just sign anything without reading it, particularly if it has such serious bearing on other people. So I would simply approach this person's supervisor, or I'm not, because we don't specialize in that field of law. I can't exactly tell you the job title of the person you'll have to approach, but approach someone more senior and actually institute a complaint. This is quite simply put unprofessional behavior, not befitting of an attorney. No attorney should be signing a document they haven't read, particularly if it's got bearing on other cases or people. And the same
almost sounds like it could be said for the second one.
Same. So the officers at the housing tribunal, though, are not always qualified attorneys. So it's the element of the professional rules and codes of conduct may not be as applicable, but maybe this is also a legal practitioner.
But in any event, there should be a supervisor.
In any event, there should be a supervisor, and this is, not acceptable. So again, both not from the person dealing with your matter, as well as their supervisor dealing with that person and overseeing their standard of work. So Ben, basically a complaint against both those people.
Yeah, I think you just need to go and speak to the supervisor of both of those people, regardless. And the disability does not come into this at all. The fact that the person is disabled or not, if they're doing that particular job, they need to read the document. Ben, thank you very much for your call. Ben, I've got literally... Yeah.
At the very top.
Yeah, but then you need to find somebody higher up than them, because there will definitely be somebody higher up than them. They're not going to be the main boss. So you look for the person higher than them and you go and have a word with them. But we've literally got a minute and a bit. I want to squeeze the last call in. Jeff from Durban, good evening.
Please, if you can help me, please.
I've got the same problem as you, so I'm dying to know the answer, Jeff.
Basically, I've got a member of family that's been ill, bedridden now, had a stroke. The family have appointed me as the power of attorney because I'm trying to consolidate all his debts and things and accounts. I've been to the banks now with a proper notarized attorney from an attorney with fingerprints on it because he can't sign or anything. And these banks are giving me such a runaround and telling me now that I've got to go to the Master of the High Court to get a juror's note or something.
Mm. Yeah, this is quite tricky, and bank.
We're not talking any vast sums of money. It's pretty small monies involved.
Unfortunately, I've also heard of this, and it doesn't. It's not linked to the sum of money at all. And unfortunately, the banks are problematic. Our stock standard advice to clients regarding powers of attorney is that it works for most institutions, not all of them, firstly, whether they're notarized or not. And then secondly, if someone becomes bedridden or incapacitated to the degree that they can't sign documents anymore, industry is leaning towards curatorship being a better solution to the issue as opposed to power of attorney, because the issue of capacity and mental capacity comes into play. So most of these organizations are limiting their risk, and they are very concerned about potential lawsuits, and that's why they actually send you from pillar to post. So best is to get an attorney and to bring a curatorship application. And
Okay, but as I say, I've taken the attorney to him. She's explained this process, all the rest. Because of the non-incapacity to sign, they've done fingerprints on it. So I assumed everything was done and
unfortunately
settled.
not. You'll need to actually approach court and be formally appointed as a curator.
Jeff, I'm so sorry. We literally
Okay,
have
all
30
right, no
seconds
problem.
left, but thank you. I've got my answer as well. But thank you so much. My thanks once again. Thanks once again this evening to Nicoline Skumanlo. She's a director of Skuman Law Inc. Attorneys, Conveyances and Notaries Public, practicing here in Cape Town, and she's been my guest on tonight's edition of the Law Report, and she'll be back again on Monday, the 13th of March. Nicoline, thank you very much for joining me.
Only a pleasure.
In next week's program, we'll be doing another labour law program with attorney Michael Bagram. We couldn't get through all the calls last time, so we're doing an extra labour law program this month. That's next Monday, the 20th of February. I'll be back with you again tomorrow evening, just after 9, with Health Matters. It's our monthly phone-in, and this month we'll be chatting about epilepsy with my guest, Marina Clark, National Director of Epilepsy South Africa. Stephen Kirk is up now with some nighttime music. Hello, Stephen.